My name is Bill Scheidler from Port Orchard, Washington. I'm 59 years old, and my experience with government corruption, judicial corruption, and attorney corruption spans 14 years and is continuing. It began when I discovered Kitsap County was defrauding senior disabled citizens by misstating the qualifications for a constitutional program specifically intended for senior and disabled citizens. That program can be read at the Washington Constitution site. It would be Article 7, Section 10. When I found this fraud, I looked for an attorney to prosecute the matter, and Scott Ellerby, who's an attorney with the firm Mills, Myers, and Swartling, took my case and filed a lawsuit with Kitsap County, or against Kitsap County. Ellerby was on the case for over 6 months and had charged me a few $1,000s, which I of course paid. 3 days before the beginning of this trial, Ellerby phoned me and said he was being asked to withdraw by Kitsap County. He told me at the time that Kitsap County raised a conflict of interest issue, and by his code of conduct, or the rules of professional conduct, he would have to withdraw. This is when I became familiar with the tactics that I could only describe as lying, cheating, and stealing that goes on by attorneys in the court system and judges who allow attorneys to engage in this conduct, and in fact they engage in the same conduct sitting as judges. To make a long story short, Ellerby in fact did withdraw on the very eve of that hearing and refused to refund my money for the 6 months that I paid him to prepare for the very hearing that he withdrew from. So I sued, and I charged Ellerby with breach of contract, fraud, and other injuries. What I want to do is present just a couple of pieces of evidence because the reason I had to sue is Ellerby, instead of acknowledging that he was being forced to withdraw, concocted a story that I in fact asked him to withdraw, and it was for my reasons or my wish that he withdraw on the very eve of this hearing. So when I filed a lawsuit, I entered a couple of documents as exhibits. One is a notice of withdrawal that Ellerby in fact signed, and I'm going to read from this notice in which he says, "You are hereby notified, effective immediately, the undersigned attorney, Scott M. Ellerby, hereby withdraws as counsel for appellants at the request of the Kitsap County Prosecuting Attorney's Office based on the allegation of a conflict of interest." I also entered into evidence a letter Ellerby sent to Kitsap County asking that they waive this conflict. He says, and I'm reading from his letter that he sent to the prosecutor, he said, "We ask that you waive any arguable conflicts of interest to allow our continued representation of the Scheidlers." And I also entered into evidence an email note that he sent to me in which he told me, he said, "If the county does not respond to my letter or refuses to waive the conflict, I would be forced to withdraw." These were all entered into exhibits. And Ellerby, the attorney, in his defense pleadings, entered the following declaration. This is Ellerby's answer to my complaint. He says, in answer to paragraph, and he notes the paragraphs that he's citing in my complaint. He says, defendant admits Mr. Ellerby voluntarily withdrew his representation of plaintiff at the request of plaintiff. So he changed the story. He told me he was being forced to withdraw. Now he's filing with the court a declaration that he's claiming that I was the one who asked him to withdraw. He also filed numerous declarations in support of many motions that went on in this case over the course of 2 years. And I'll just read, I think he filed 4 declarations, and he says at number 2, and I'm reading from this from one of the declarations, I represented the plaintiff from May through November when I voluntarily withdrew from representation at plaintiff's request. So he is blatantly lying about why he withdrew from representation. Now, I just want to quickly read a law that governs attorneys. This is a law passed by the legislature that requires every attorney to subscribe to this oath. And it says, every person being admitted to the practice of law in this state shall take and subscribe the following oath. And it goes on, it says, I do solemnly swear that I will employ for the purposes of maintaining the causes confided to me such means only as are consistent with truth and honor, and will never seek to mislead the judge or jury by any false statement of fact and law. That is the oath an attorney must take before being allowed to practice law. Clearly, there's 2 statements by Ellerby that do not fit together. Either he withdrew, as he told me, at the request of Kitsap County, or he withdrew based on me asking him to withdraw. The evidence was put in the court. The declarations were clearly entered as exhibits. And there's one more law, it's called perjury. And perjury is when you simply, under oath, lie about a fact. And this law is again, can be found in the laws of Washington State 98.72.010. And it says a materially false statement means any false statement, oral or written. And clearly there's false statements being made by Ellerby. Now, to make this long story short, this trial went on for 2 years. Judge Hartman made a number of astounding rulings, in my opinion, but the most unbelievable ruling is when he decided that my complaint was frivolous, that all of these statements were not material, and he dismissed the case 1 week before it was to be heard by a jury. And not only did he dismiss it without going to trial, but he awarded Ellerby $132,000 because I had the nerve to file a frivolous complaint, despite the fact that Ellerby broke his oath, committed perjury, and lied. And all of these are simply the entire essence of my case, and they're material to the case. So the case is still going on because it's in an appeal, and the first appeal went to the Court of Appeals, and they actually reversed the award, the $132,000. So I've got to feel a little bit better that maybe there's justice to be found somewhere in the system, but it's certainly not certain. So even though the court reversed the $132,000, they did not address the perjury. They did not address the violation of oath. They simply, in my opinion, threw me a bone so I would just go away without pursuing the matter. But I'm still involved. I filed a petition to the Supreme Court of Washington State to review the Court of Appeals decision and address these blatant violations of law and the disrespect that citizens suffer at the hands of corrupt attorneys and judges. So I hope that this, along with all of the other testimony you'll be hearing, shows that it is a good old boy network. And I'm saying the legal profession, lawyers and lawyers become judges, they all engage in deceit, dishonesty, and very little of what happens in a courtroom has anything at all to do with the law or the facts. And it's a crime, and I sure hope that the message comes through loud and clear. Thank you for your time, and good luck to us all.